Recently, we asked our Patreon backers what video topic they'd like to see tackled next, and there was a clear winner: the UK's complicated, non-existent constitution explained. So here we are making that video. If you'd like a say in the videos that we make, then sign up to donate from as little as $3 a month. On top of getting a say in our video topics, you can also get exclusive merchandise, discounts on our store, early access to some of our videos, and behind the scenes content. In fact, if you'd been subscribed, you would have got this video a day early. Find out more at patreon.com/TLDR news. We've actually talked about the UK's Constitution a number of times recently. Brexit in many ways has been a good test of the UK Constitution, with Brexit really pushing the edges and setting new precedents. Most notably, there are a lot of comments on our video when Speaker of the House of Commons John Bercow used old parliamentary practice to stop May from bringing back her deal. This is really tied to the idea of the UK's Constitution. And, well, let's say that the comments from that video suggested that there might be some confusion about whether or not the UK has a constitution, so we thought we'd make a video to clear that up for you. While it's true that the UK doesn't have an explicit, written constitution with a capital C, like the US for example, the UK does have an unwritten or uncodified constitution. This is relatively rare in modern politics. Only the UK, Israel, Saudi Arabia, New Zealand and Canada have uncodified constitutions. And the last two only have uncodified constitutions because they used to be British colonies, and so their political systems are based on the UK system. The UK's constitution draws from four main sources: statute law, common law, works of authority, and conventions. Statute law is probably the most important part of the UK's constitution. Statute law refers to acts passed by Parliament. Not all acts passed by Parliament are constitutional. Generally only those that affect how Parliament or the judiciary function, or the ones that affect the relationship between the individual and state, are considered constitutional. A recent example of such an act might be the Constitutional Reform Act, there's a clue in the name there, which passed through Parliament in 2005, creating the UK's Supreme Court. Now we don't want to get too bogged down in any legal stuff, mainly because no one at TLDR News is a lawyer, but this concept has been recognised in UK law. In 2002, in the famous Metric Martyrs case, Lord Justice Laws, the judge who was ruling on the case, declared that certain acts, namely the Parliament Act and the Human Rights Act of 1998, were constitutional statutes, which could not be implicitly repealed by a new law that contradicts them. A similar thing happened in 2012, when Lord Hope, ruling on a different case, held that the Scotland Act can only be expressly repealed. It cannot be impliedly repealed. That is because of its fundamental constitutional nature. Implicit repeal is when an old act is effectively ignored once a newer one passes through Parliament and contradicts the old act. The old law doesn't have to actually be repealed in parliamentary time, and is just ignored in the future, or implicitly repealed. On to the next source of the Constitution, common law, also known as case law. This refers to legal precedents created in particular cases that are not enshrined in statute law. A good example of this is the infamous Factor Tame case. This is when Spanish fishermen brought a case against the UK Parliament, who were demanding that ships in UK water had to have majority British owners. The European Court of Justice ruled that this Act of Parliament contravened EU law, and therefore had to be suspended, setting the precedent that the EU's law superseded UK law. Alright, so if you're still with us, the next source of the Constitution are works of authority. These are well-known constitutional books or documents, such as Bagehot's The English Constitution, the Magna Carta, and A.V. Dicey's Introduction to the Study of the Law and the Constitution, which introduce the concepts of parliamentary sovereignty and rule of law. These are not legally binding, but often hold huge political weight, and has historically shaped the way that the UK's political system has developed. The most recent candidate for a work of authority is the Cabinet Manual, written by Gus O'Donnell while he served as Cabinet Secretary, the highest post in the civil service, in 2010. It sets out the main laws and conventions which affect how the government operates. We've left a link to the PDF in the description below if you want to check it out. Now for conventions. The Cabinet Manual we just mentioned describes conventions as rules of constitutional practice that are regarded as binding in operation but not in law. Despite the fact there's no legal punishment for breaking a convention, they are almost always adhered to by politicians. There are lots of constitutional conventions, some of which you will never need to know or hear of, but there are some main ones. The Salisbury Convention is the convention that the Lords don't block bills that were in the party's manifesto. This convention was created after Labour's landslide in 1945. When Labour won that general election, only 16 of the 761 peers sitting in the House of Lords were Labour affiliated. So the massive Conservative majority could effectively block any legislation it felt like blocking. Lord Salisbury, the Conservative leader in the House of Lords, recognised how ridiculous this situation would be, and agreed that the Lords wouldn't block any legislation laid out in Labour's manifesto. It used to be that the power to declare war or take military action was solely in the hands of the Prime Minister. In 2003, Tony Blair did ask for Parliament's approval before he went to war in Iraq, but he made it clear that he was probably going to do it anyway, because he had the royal prerogative to do so. In 2007, after the Iraq war hadn't gone all that swimmingly, Gordon Brown decided to set a new convention, that the government requires the backing of Parliament before it can declare war, or engage in significant military action. You might now see why some people get a bit worried about an uncodified constitution. It's held together by conventions that can be broken, acts of parliament that can be repealed or changed, and some ancient books that don't actually have any legal weight. So what's to stop some tyrannical government from flipping all of this on its head and turning the UK into some totalitarian dystopia? Well, legally nothing, to be honest. But this never seems to happen, touch wood. There are enough checks and balances along the way, and conventions and so on hold enough political weight to prevent a complete upheaval. In fact, when you look around the world, having an uncodified constitution that's flexible to change and allows for organic modernisation might actually be an advantage. The UK doesn't have any insane, outdated rules that are constitutionally entrenched, and we don't have an unelected judiciary making important constitutional or political decisions. Anyway, that tops it off for this video. This is one of the first videos we've done on political theory, so if you've enjoyed it, make sure to comment below and tell us what you'd like us to cover. Equally, if it didn't interest you at all, and you prefer we stick to the winning formula of endless Brexit videos, then tell us that in the comments. Make sure to subscribe to be kept up to date when we post more videos. Also, you can find exclusive content, including extra bonus bits from this video, on our other social channels. You can find us by searching for TLDR News.